I'm Doug Lichtman, and in this video in the patent series, we're going to be thinking about prior art. We'll dig in over the slides ahead, but at a high level, prior art is our phrase for what we knew before you knocked on the door and asked for a patent. Prior art is the evidence that we gather to say, hey, this is what we understood, this is what we'll compare your invention to figure out, did you make something that's new? Did you make something that is non-trivially interesting, moving us forward? Do you qualify? There's a bunch of law, there's a bunch of vocabulary, but at a high level, that's what we're trying to figure out. What evidence do we look at? And how do we judge your invention in light of that evidence? Some of the ideas that we'll see is we're going to ask whether your invention is literally new, like is it something we've seen before? We're going to ask if your invention is obvious. That's actually the word the law uses, obvious. Is your invention obvious? It might be new, but is it such a base hit that nope, no patent for you? We're also going to be looking a little bit at timing. How long did you wait? What did we learn over time? And how does that compare with the date you actually showed up and filed? Again, we'll unpack all of that as we dig into material in this deck. Let me start though, and I'll do this for a lot of the videos in the patent series, let me start by pointing out when this question matters. Because in patent law, we look at patents a bunch of different times. We look the first time when someone applies for the patent. So someone literally submits the application to the United States Patent and Trademark Office, and when they apply, the government, there's a government worker whose job it is to look at the application, evaluate it, maybe go back and forth a bunch of times in what we call patent prosecution, maybe go back and forth a bunch of times and ultimately decide either yes, that patent should issue, or no, there's a problem. And so one time that we look at prior art is during that initial process, the application process, when someone with some knowledge already is assigned to you. Remember, there are a couple thousand people working at the patent office. Someone who knows something about this area is assigned to you, and they go through the process of looking at your application in light of the prior art. One time we see it during the application. Another time this happens is, of course, in litigation. And so when you sue me on your patent, one thing I might say is your patent never should have issued. Based on the prior art, what you brought to the table, even though the government allowed it to issue, it turns out that what you brought was too similar to the prior art. We already knew it, it was obvious, something like this. In court, I can challenge patent validity by pointing out prior art, pointing out the things we'll be talking about. You also see prior art raised in processes where people bring the patent back to the patent office. And this is really important. As I speak here today, there's this thing called IPRs, inter partes review. And IPRs allow anybody, you, me, anybody, to grab a patent, bring it back to the patent office and say, I think you guys let this issue wrongly. And if you clear the right procedural hoops, and those change from time to time, depending on who is in charge of the federal government, sometimes that's a really tough threshold to clear, sometimes it's not. But if you make whatever showing is required at that time, the patent office will take the patent back and look again, this time in light of what evidence you brought. And indeed, if you're bringing one of these petitions, if you're asking for IPR review, you get to be involved. And so the conversation isn't like the old one, where it's the applicant and the government. It's actually you and the other side all in the room together fighting it out over a period of months to years. All of those settings, this can come up. Prior art can be in the initial process, prior art can be during litigation, prior art can be during an IPR, and then obviously if you and I are just talking, thinking of licensing your patent, you're knocking on my door and threatening to sue. If we're just talking, obviously we're going to also think about prior art, because you and I both know that if we don't come to terms, we might end up talking about prior art in these other places. All right, that's what it is. That's when it matters. Let's dig in on some of the details. I have to start with some vocabulary. And so let's learn a couple words that will help us talk about prior art rules. One word that we have to know is the word reference. A prior art reference is simply a document or a bit of evidence that we're going to deem acceptable to then say, all right, what did we know? here are some references. It's the evidence we're going to use to establish what we know. And this is actually kind of really important because we need a process to figure out what did we know. Otherwise, in every case, someone will show up in court and somebody else will say, I knew that. You got to have a set of rules of what references count and how will we think of those things. And indeed, it's really important because a lot of really amazing ideas in hindsight might not look as breathtaking as they were. References is our vocabulary word for the evidence that we will admit as evidence of prior art. It's a reference. The verb anticipates has special meaning in patent law. When I say that a reference anticipates a patent claim, I'm saying that that reference has every element of the claim. Not just some, not just most, all of them. A reference is said to anticipate if literally every element of the claim is actually present in the reference. If I have 9 out of the 10 parts, I have almost the whole mousetrap, but I'm missing one detail, that reference doesn't anticipate. It might be prior art, but it doesn't anticipate. Anticipation is a very specific word. All elements that are in the patent claim are actually also in the reference. And it's an important word in the sense that if I have one of those, if I have a reference that anticipates, that's a key cog in my argument that what you did, it's not new. How do I know it's not new? I had all the elements already in this reference. The verb anticipates. There's a related idea, this idea of inherent anticipation. And that gives us the tiniest little bit of wiggle room. It says that sometimes you'll have a reference that has all the elements, but they're not explicitly listed on the face of the document or the object. And here's an easy example. Imagine I have prior art documentation about a water bottle. And the prior art documentation says it was made of plastic, it has a ribbed structure, it's used to hold water, it says a bunch of stuff, but it doesn't explicitly say that before it's filled with water, it's hollow. Technically, you might say, ooh, that doesn't anticipate, because if my patent claim talks about the container being hollow, you'd say, well, it didn't say hollow, it doesn't anticipate. And so we have this special rule about inherent anticipation. And it basically says that if something is absolutely for sure scientifically true, even if it's not explicit, we'll recognize that it's there. And so inherent anticipation is a word we use to kind of modify the idea of anticipation. And we say sometimes that a prior art reference inherently anticipates because a lot of the stuff is explicit on the face, but some of the stuff we can now just look back and tell you, yeah, that was there too, even though it wasn't explicit. This is really important in a class of cases involving drug discovery. As you might know, a lot of modern drugs are what they call polymorphic forms of other molecules. So it's some original molecule, and then there's a different crystalline structure that I find a couple years later, and that's the one that's amazing. That's the one that has the right solubility. That's the one that has the right pH responses, whatever it is. And what we see is, drug companies will come in and try to patent the original molecule, and then they'll come back a couple years later and say, I have yet another achievement. Look at my polymorphic form. And in a lot of those cases, what happens is an opponent says, terribly sorry, kids, you can't patent the polymorphic form because it's inherently anticipated. And usually what they mean is that when we were making the original molecule, even though we didn't think about it, even though we didn't say anything about it, even though it wasn't the purpose, when we were making the original molecule, we kind of accidentally made some of the polymorph also. It just happened. The pH changed and the crystalline structure adjusted. It sat on the shelf, and over time, some of it morphed into the other structure. And the argument in a lot of these cases is you get your original patent, the original molecule, sure, but you don't get the polymorph because the argument goes, we already had it inherently. We didn't talk about it, we weren't trying to make it, but it was there because these molecules naturally morph sometimes, depending on temperature and pressure and other considerations. They naturally morph into these polymorphic forms, even when we're not looking. So this comes up actually a bunch, inherent anticipation. The last vocabulary I want to introduce is the idea of rendering obvious. And this is the next verb. Anticipate is all elements in a single reference. Sometimes I don't. I have 9 out of the 10, 8 out of the 10, 3 out of the 4. And what I want to argue is, yeah, but giving you those pieces, maybe those pieces, plus some other document that teaches us something related, plus some basic understanding from science, I might want to say a couple of things cobbled together render obvious your claimed invention. It's not anticipated. I don't literally have one reference, but come on, if you put a couple of things together, what you did isn't all that impressive. And the fancy phrase the lawyers use, renders obvious. All right, let's look at some law. The law here is a little messy because we made a huge change to this area of law that was effective in 2013. And so I labeled the law as pre-AIA. AIA stands for the America Invents Act, which was the law that implemented this change effective 2013. We're going to look at the old law because we have tons of cases on the old law, so I can really explain it to you. We're also going to look at the old law because the patents that were issued under the old law, they're still important today. 2013 isn't that long ago. We're still litigating and licensing and thinking about those older patents. So we'll start with the old law, and at the very end, I'll show you how the law changed. Just to not keep you in full suspense, the big change, the system that we always had up until the effective date of the new one, the system that we always had was what we call a first to invent system. And the focus of it was, if you invented first, we're going to try to give you the patent. The new system is a first to file system that says whoever files first, we try to give them the patent. It's so much simpler. Filing dates were really clear. It's the date you knocked on the door and handed us a document. I give you a timestamp. I know when filing happened. First to invent was messy. When did you invent? How are you going to prove it? Messy. And so we moved from first to invent, the old system, super romantic, trying to give it to the true first inventor. We moved instead to first to file. So much easier to run. I'll point out to you, the rest of the world was on first to file already. We were the last real country to move. Everybody else moved to first to file, and in part everyone moved because our life experience under first to invent was that almost every time the party that won under first to invent was also the first to file. Which is to say, either if you're first to invent, you tend to be first to file also, or it was to say that people couldn't really prove their invention dates. And so we were kind of stuck guessing the filing dates as a good proxy because people had trouble proving an earlier invention date. Either way, old law first to invent, new law first to file, but almost all of it beyond that is extremely similar. And so let's start with the old law first. This is section 102 of the Patent Act pre-AIA. 102A tells us you can only get a patent if what you bring us is new as of the time you invented. And let's just read it for a moment. So a person is entitled to patent unless the invention was known or used by others in this country, or patented or described in a printed publication in this or a foreign country, before the invention thereof by our applicant. So before our applicant invented, you can get a patent unless before our applicant invented, the invention was known or used by others, patented, described. And the way I like to think about 102A, and indeed all the stuff we'll do in this video, I have my little mental checklist, which I will share with you. Every time I read one of these bits of law, I ask myself first, what art counts? What references do I look at? Is it patents? Is it printed publications? Is it what was known by others? What do I look at? As of what date? Here I've been mentioning to you first to invent. It says the invention date. Did we know it as of the invention date? I ask myself, hey, what's the date relevant for this bit of analysis? And then what's the comparison verb? What verb do I apply? And here I want to apply the word anticipates, all elements in a single reference. And so if you go back to 102A, you can break down the categories, right? What art? That's the beginning of the sentence. I look at evidence that was known or used by others in this country, patented or described in a printed publication anywhere, right? That's my bucket, what art? What's the timing? Before the invention thereof. And then I will tell you again, the verb is anticipates. I need a printed publication that has all elements of the claim to knock it out under 102A. Let's dig in for a touch more. I told you that in the beginning is the list of references, and let's just pierce a couple of them to give you some of the flavor of the law. So under 102A, if it was known or used by others in this country before you invented, you can't get the patent. And my favorite case in the line of explaining what does it mean to be known or used by others was a dispute about a patent used in tractor pulling. Now, I grew up in Ohio, so I know about tractor pulling, but in case you don't know, it's kind of like a sport where you're trying to pull a given weight at a given speed and distance, pulling it using a tractor. And there are competitions. Come on, it's Ohio. We do funny stuff. Fine. Someone had a patent on the load that you would use in these competitions. They'd come up with a clever way to design the load so you can control how much resistance it gave when you're trying to pull it. You can make certain adjustments. Let's just stipulate it was an interesting load instead of just like piling a bunch of hay on the back. It was a more interesting way to drag these tractors and limit their ability to move. Someone filed a patent on this. Someone else came to court and said, no, 102A. Before it was invented by this supposed inventor, we knew about it. Known or used by others was the category before the invention by this other guy. And the evidence, I'm going to call the three people Larry, Curly, and Moe. Larry, Curly, and Moe, their testimony was that they were young kids in whatever place this was, and they loved this sporting event, and that they had sat at mom's dinner table one night, and they had sketched out a pull that was exactly like the patented one. And they said they drew it on the tablecloth and they knew it, known and used by others, Larry, Curly, and Moe. And the tablecloth wasn't admitted into evidence, it was just their testimony. And indeed, Larry and Curly said one thing and Moe had a slightly different story, it turned out. But the court looked at it and said, even if I take your story as true, I don't think known or used by others includes this fact pattern. And the court made 2 points that become important to understanding this bit of the law. It said, look, when we say known or used by others, I actually want something that is kinda a little bit public. Why? Well, one, it helps you know it's true. Right? Known or used by others, if it's just private, Larry, Curly, and Moe at the dinner table, you guys might be lying. And so one virtue of known or used by others publicly, with a little bit of public involvement, is I will have more confidence that the story you're telling is true. The second thing the court said, though, the court said, even if you could bring me the tablecloth and we could carbon date it based on a spaghetti stain, so we knew you were telling the truth, even if you were telling the truth, I still wouldn't deem this to be known or used by others. Because again, I want it to be a little public. And this time the court said, the reason I want it even more than evidence is if I'm going to knock out somebody's patent, I want to know that the information was on its way to being meaningfully public. The patent hopefully would do that. The patent holder patented and obviously was then going to go do something with the patent, at least we hope. And so if we're going to say, no, it's invalid, 102A, we have a prior art reference that comes earlier that knocks it out. If we're going to say that, okay, got to be public. Because then I'll at least know that while I'm knocking out the patent, there's a pretty good chance this invention was going to come into the public's use anyway. So Larry, Curly, and Moe, even if you're telling me the truth, you don't count. Known or used by others actually means known or used by others publicly. And again, for these two reasons, evidence, and I kind of want the information on its way to being meaningfully public before I'm going to count it. Famous case to help us understand that phrase. Another phrase, again, my checklist, one thing I always look for is what references count. Here, another type of reference that counts are printed publications. And lots of fun cases here. The flavor is, like this one. This is a little website just showing some PhD dissertations from MIT. And there are all these cases about things like this, where the prior art reference thrown on the table is a PhD dissertation, or something else that, can we say it? No one reads, right? PhD dissertations, your advisors maybe read it, your mom said she read it, but does anyone really read, find, search? Not so clear. And there are a lot of cases thinking through, does it count as a printed publication if it was printed on paper or otherwise qualifies? The internet probably qualifies along certain dimensions. Lots of stuff might qualify, but does it count if we're not sure it's really going to be findable by people of skill in the art? And there are all these cases trying to figure it out, and they talk about, was their dissertation made publicly available? Was it indexed? Right? Was it just a website that said, here are some dissertations? Or was it organized in some interesting way that made it findable? There are a lot of cases kind of feel out, all right, you've got this document, how findable is it? And again, on the internet, this has become huge. On the one hand, Google search can find anything. On the other hand, it can't be that every shred of information put on any website anywhere counts. And so we have to figure out, like, how accessible must it be? And these old cases about dissertations, or there are cases about like public presentations where I have up at the front of the room a poster board with some information on it, but I only let a certain number of people in, and I tell those people, don't talk about this. This is just a private, I'm giving you a preview of my research. Right? Thinking about where these lines are, there are a bunch of cases under this banner of printed publication, just to decide, like, how open are we really? Is it anything that printed counts? Or will we say some things are not public enough? Note the theme here. Known or used by others publicly. The spaghetti stained tablecloth not good enough. Here again, is a dissertation, but what if it's not indexed and nobody read it? I'll point out to you, by the way, that these cases don't ask, should the new inventor have found it? That's a different question. And many times the answer is going to be, well, no. That the cost of finding this would have been way too high. We want inventors to look a little bit. When you have a new problem in industry, yeah, I'd like you to go to the library and look at existing solutions. But I don't want you to spend 6 years researching existing solutions if your alternative is to go into the laboratory and go figure out what might be a brand new one that totally works. And so inventors, obviously trade off between looking at what we already know versus inventing something new. This law doesn't kind of put the law in their shoes and say, well, you should have found this, therefore. That's not what the law does. Sometimes something counts as prior art even if we understand why you didn't find it. Even if it was totally reasonable that you didn't find it, you shouldn't have found it. Even if the only reason we found it is there was litigation and enough money was at stake that some fancy lawyer spent a bunch of money and found it for you. And indeed, a lot of the hard cases, that's exactly what happened. Prior art that is published and public, we don't even see that in the cases. Of course, we're not going to dispute that it was in a book in a library, right? Nothing fun to talk about. These cases about like dissertations, the reason we have them is no one found them. No one really read them. But then there was a litigation and there was $100 million at stake. And so an army of lawyers went out and at that moment, they then had the incentive to go hunt dissertations, to go look back in time and try to find this. And that's why the reference comes into court. And so the courts try to figure out, like, when do we allow that? When don't we? I will warn you, we allow it all the time. Lots of stuff comes in that you or I would say, there's no way the inventor would have found that. You and I would say, I'm not mad the inventor didn't found that. That would have been an incredible waste of resources at the time. And yet, even having said those couple things, we still let the reference count. And what it does really is it causes us always, as patent holders, to be nervous. I might be willing to take a more reasonable settlement because I know if I don't, you might put a bunch of people on airplanes and go read dissertations in France and Spain and go find something. There's always this risk that there will be prior art that will be found in the case. And along some degrees at least, that means me as a patent holder is going to be a little more reasonable in my ask, a little more nervous about pushing this too far. Dissertations, just another piece of what references do we look at. Again, 102A big picture, we have the bucket of prior art, right? Known or used by others publicly. Patented is easy, right? Patented documents are organized and publicly available, easy. Printed publications in this or foreign country before the invention thereof. This is the other really important piece of 102A. The date we judge you on is your invention date under the old law. Remember, we're going to move to a filing date when we get to modern law. Under old law, invention date. As the date you invented, was it literally known? Was it anticipated? Did we have a single reference that fits in one of those buckets that had your claimed invention? If so, sorry, you didn't invent something literally new. 102B. We'll read it in a minute. 102B does different work. 102A says, when you invented, was this literally new? And you've got the tools. 102B says, all right, now, even under the old law, let's look at when you filed. Because if you invented and then you lollygagged, you invented and you took some day trips and you went to Hawaii and you daydreamed for a few years and you putzed around, at some point, if you waited too long, we don't want to give you the patent. You invented first, but because you waited, we say, no, you waited too long. And so 102B does that work under the old law. Because remember, the main move in the old law was first to invent, so we needed a 102B to say, yeah, first to invent, however, if you wait too long, I'm going to look at your filing date, and if it's too long, nah, you don't get the patent. And the way too long was defined was asking, what did we end up knowing 1 year before you filed? So great, when you invented, it was brand new, you were first, congratulations. But then you waited. And as you waited and you waited and you waited, other things happened. Maybe you did some of those other things. Maybe you invented a mousetrap and you started using it publicly. Maybe you started selling it to people. Maybe you did some stuff. Maybe other people did stuff. You were first, but not by that much. And 6 months later, someone else made a mousetrap just like yours. What happened after your invention date? And might some of that activity have anticipated your claimed invention? After you invented, is it possible that a document came out that had all elements in a single reference? Is it possible that someone sold literally your mousetrap? Maybe you, maybe someone else. As we wait after invention, things happen. Under 102B, we say, we're going to look at you when you file. We're going to give you 1 year for free. We're going to back up 1 year. And we're going to say, what did we know 1 year before you filed? And if we knew your invention 1 year before filing, and again, we'll get to the details in 102B in a second, but if we knew it, we in essence say you waited too long. Like, come on. By the time you filed, the cat had gotten out of the bag. We knew. And so 102B, they call it a statutory bar. Statutory referring to the fact that in the law, I guess. Bar meaning, sorry, we bar you from patenting. And it works hand in hand with A. A judges you at invention, you better be new, and B shows up and says, don't lollygag. If you wait a long time, you increase the risk that we're going to say no when you finally show up on our door. Let's read it now. 102B, you get a patent unless the invention was patented or described in a printed publication in this or a foreign country, or in public use or on sale in this country, more than 1 year prior to the date of application. And some of this language is familiar from 102A, patents, printed publication. Note though the public use and sale language, slightly different than 102A. Note too, you could accidentally create these references yourself. That's a really big difference from 102A. You can't mess up your own invention date. You can't publish a paper before you invent. Not worried about that. But you could mess up under 102B. After you invent, you make a sale. And that sale is the prior art reference that ruins you under 102B. So some interesting different parts. It could be you yourself that ruins it. It's different timing and all the like. Again, my checklist, I think it's really helpful. Ask yourself every time you do a new bit of law about prior art, what art? As of what date? What's the verb? And as we start, by the way, 102A and 102B, the verb is anticipate. I just know that from the cases. It's not written there by Congress. I know that from the cases. Anticipate all elements in a single reference. That's what the verb is. Again, in 102B, the biggest change I want to point out to you is the date changed. 102A is date of invention. 102B is 1 year prior to filing. Why? I think intuitively, but let's say it out loud just in case. One reason is it gives you some pressure to hurry up and file. If we just did 102A, once you were the first to invent, you'd be like, yay, I'm done. I won. I don't want you to ever feel that way. I don't want you to be tucked in until you've filed. Filing is a really important moment for the system. So when you join our system, you disclose the information. We start the clock on your patent rights. I want you to show up. And so we have a rule that says hurry up and file. Every day you wait, You're adding risk that there will be some activity in the real world that will come under 102B and ruin your patent. Hurry up. Secondary intuition here is we don't want you to confuse the public. If you invent it and you start doing stuff, showing it to people, selling it, and so on, people might think, hey, that's free for all to use. I don't see any patent, it's free. We want you to hurry up and patent so people know that even though they're seeing it in the wild, it's protected stuff. They can't use it quite yet. I don't want to trick, I don't want to sucker punch the public. Third piece is I don't want you to cheat the patent term. Again, once you invent, if you then start selling your mousetrap, I don't want you to sell it for like 10 years and then come patent and get 20 more. Once you invent, I kind of want you to show up in my system. We'll start the 20-year clock. I don't want you to do a bunch of activity before you start the patent clocks. Don't cheat our rules. We want to give you 20 years, not a bunch of sales followed by 20 years. 102B statutory bar. In lots of cases, we just touch a little bit here, but I want to give you a flavor of the law. So let's think for a minute about this public use and on sale category. One of my favorite cases involves what I think was the original Rubik's Cube. Some guy who had another boring job invented the Rubik's Cube, and he built a little model, so cool, figured out how you make it so it turns in all those directions without falling apart. Cool. He built this, he showed it to his friends, had some parties. Nothing came of it. He brought it to work and put it on his desk, and his boss walked by. And his boss said, why aren't you working? No, the boss didn't say, why aren't you working? The boss said, wow, that's really cool. And it ended up that he and the boss made a deal, and he sold this achievement to his boss, and his boss then helped him knock on the door to all the toy companies and try to get attention for the Rubik's Cube. Once it was super successful, there was litigation. And the question was, does the sale from the employee to the boss start this 1-year clock? Because remember, 102B says on sale, that's one of the things we look for, and it's 1 year prior to filing. So when he made this sale, did that start a 1-year clock? And our inventor and his boss argued, no, this wouldn't be right. We might have needed more than a year to figure out how to get it patented, to get our business up and running. They argue that when the law says about a sale, they really aren't talking about the sale of the underlying idea, which is what happened here. That sale really is a sale of an embodiment. We're trying to stop you from selling the thing you ultimately will sell if you get a patent. We're not trying to stop you from rejiggering your corporate structure. Here, moving it from one guy all by himself who didn't know quite what to do with it to a partner who then really helped him out. And this move, adopted widely by the way, I love this move because it's patent law being aware of the real world. We don't want to distinguish a case where it's like this, where some small individual inventor has to do a couple transactions just to get ready to do the bigger job of patenting and monetizing. We don't want to treat them worse than we treat an in-house employee at a big company. An in-house employee at a big company, the transfer happens naturally. It's under the employment contract usually, and so it's not a sale. That means if I treat the Rubik's Cube like a sale, I am disproportionately hurting the little guys. If you're an employee, it's not a sale, so the company isn't hurt at all. But if we treated this as a sale, my independent inventors would be hurt quite a bit. And the courts figured that out. Congress didn't write that down for us. They just wrote on sale. But in one of the early cases where this fact pattern was pointed out, the court said, we're not going to count that. That's not what we mean. Sales should be something closer to a sale of the very embodiment under the patent. Again, just adding some nuance to the phrase. I'm going to add one more bit of nuance. There was another set of cases where there was a sale, but the seller hadn't actually invented the thing yet. The famous case was about like a jet wing or a jet engine, and the inventor made a deal. Yeah, I'm going to sell you a jet with that. It'll be delivered in about 2 years. And they made the deal, they got the money, and then they went back to their room of engineers like, oh my goodness, we got to make this now. I've sold it, we got to figure it out. And the question again was, does that sale count? And here again, it would be devastating to this type of business structure because they made a sale and they might not invent within a year, let alone invent, get a patent lawyer and file successfully. And here again, the courts were really thoughtful about it. And they said, you know what? If you make a sale, but the achievement is not ready for patenting, that sale doesn't start the clock. We will give you time after the sale to get ready to patent. And we'll kind of start the clock when you've done both things. You've made a sale and it's ready for patenting. And this might sound silly and what kind of scam is that, Lichtman? But this is actually really important in a certain area of inventive activity. Imagine, for example, you really are making fighter jets for the government, or satellites, or space equipment, or something like big ticket and big deal and kind of a reach, like a moonshot, if you will. A lot of that stuff is funded by contracts that are written when the achievement isn't done yet. The government, for example, comes in and says, I'd really like a fighter jet that can do the following things. Here's a first payment toward it. And then the company uses that money to do the research and development. They work with their customer. Here's a demo. Let me show you. Here's what it's doing right now. What do you think? Any suggestions? Right? One way we do inventive activity is this. Not all. Some inventive activity is funded by investors, and you take it soup to nuts, and you don't make a sale until it's done. Indeed, maybe a lot of inventive activity is done that way. But there's this other model where the inventive activity is kind of done in partnership with the customers. You make the sale, you use that money to actually do the research, you use that relationship to make the research better and faster and more satisfying to the customers. And by reading the law the way the courts ultimately did, we made this possible. We made it possible for people to put money down before the invention is done and not lose their patent rights, in essence. Not at the clock start. Oh, you made a sale. If you're not on the moon within a year, you don't get any rights. We don't do that anymore. We don't do that ever. Like when that got raised, the courts realized we want to make room for a lot of different business models. The Rubik's Cube example, little guy coming up with the achievement and moving into a partnership. Here, someone's selling vaporware. I get it, like stuff that doesn't exist yet, but not as a trick, not as a fraud, as a way of funding and informing the work. Lots of cool cases like this, adding nuance to what counts and what doesn't in these categories of prior art. That's 102A and 102B. You can see on the slide there's a C and a D and an E, and we're not going to do those here. These are the big two. A is novelty. Was it new when you invented? B is the statutory bar. 1 year before filing, what do we know now? 2 different rules, one judging an invention, one judging how quickly you filed. Now I want to add 103. We're still pre-AIA, old law, before the American Invents Act, before 2013. We add one more piece, and this piece fits in with the prior ones. So 102A and B, I pointed out to you, the verb is anticipates, all elements in a single reference, which is really constraining. We don't necessarily have that. Even if what you did is painfully obvious, low-hanging fruit, I might not have a single document that says exactly what your lawyer wrote. Okay, fine. 103 says, in addition to anticipation, we will also use the prior art to judge whether or not your claimed achievement was obvious. And let's read it, then we'll talk about it. Here's what 103 says. A patent may not be obtained, though the invention is not identically described as set forth in 102, if the differences between the subject matter sought to be patented and the prior art are such that the subject matter as a whole would have been obvious at the time the invention was made to a person having ordinary skill in the art to which the subject matter pertains. Patentability shall not be negative by the manner in which the invention was made. Wow, lots of stuff. Let's go back. A patent may not be obtained even though it's not identically disclosed. That's just reaffirming what I've already told you. 102A and 102B are about identically disclosed anticipation, all elements in a single reference. You might lose even if you don't trigger 102. When? Well, if the differences between the subject matter you're trying to patent and the prior art are such that it would have been obvious, that's the word Congress used, obvious when they write at the time the invention was made. I'm going to actually tweak that in a minute because we don't honor that bit of this law. But they give us a time. The time is obvious at the time the invention was made. Obvious to who? Obvious to a person having ordinary skill in the art. It's a whole bunch of words. What's the point? The point is we judge this not from your perspective or my perspective or my wonderful mother's perspective. We judge all this from the perspective of someone who has skill in the art. If they had seen the prior art, and they had looked at it and they kind of know roughly what they're doing, would they have said, come on, man, that's obvious? We get this framework. You know my checklist. It works for all of the prior art sections. What art counts, as of what date, what's the verb. Here, the magic of 103 is the verb. That's the most important thing I want to point out to you. We changed verbs. 102A and 102B were anticipation. 103 is renders obvious. It's a different test. Yeah, it's there. See, I don't make this stuff up. There it is in my slide from Congress. Would it have been obvious? When we do it, one of the cool things about this part of the inquiry is that I can put together more than one reference. Anticipation means all elements in a single reference. So I put one reference in the table at a time. For obviousness, I might take something in a book and something in a patent document and some evidence of some laboratory experiment. I might put some things together and say, even though none anticipates on its own, collectively, they render obvious. And again, we've got to be careful about this. What I don't want you to do is do an old school ransom note. Remember in the old movies, I could write any message I want by going to the phone book and cutting out letters and pasting them to make the message. I don't want you to do that to my patent system. I worry that once I show you a patent, what you're going to do is look back and say, mousetrap. I have this other reference that has cheese in it. And I have this other reference that uses springs. And I have this story about how much people don't like mice. And I don't want you to just kind of go backwards and use my patent as a roadmap to cobble together a bunch of stuff. And so we're going to be careful and try to really do the analysis of, was it obvious from the perspective of someone skilled in the art? Would they really have put these references together and said, no, I'm pretty sure that's right and that'll work? And so it's interesting you can put in a bunch of stuff together. That's the magic of obviousness. Not just one reference. Could be multiple references. Could be references plus just some basic skill, like a scientist who is well-trained plus these two books. You can put things together, then we try to tell you don't be piggy about it. If you have to put 40 things together, it probably wasn't obvious. If you are using the patent as a roadmap, probably wasn't obvious. We're going to be careful about it, but you are allowed to put in multiple references. And as you can imagine, we do this a lot, right? If you think about how we argue these cases, I like 102B better than 102A. 102B was the one about 1 year before filing. 102A was the one about the date of invention. I like 102B better than 102A because I know what the date is. 1 year before filing is a date I can look up. So if I have to litigate against you and I find a prior art reference, I know if it counts under 102B because I know when you filed and I could do the math of subtracting 1 year. Whereas I'm nervous to always use 102A because I don't know quite when you invented. That's going to come out later when we depose you and you show me your documents and you might surprise me about when you invented. So I like 102B better than 102A because I know when the timing is. So I'll use that if I can. And then I like 103 better than 102B because I don't have to have absolutely everything in one document. I think there is. I could tell the court, hey, I think it's a 102B reference. I think I win. But if you disagree, Your Honor, consider it as a 103 reference. If it doesn't have everything, gosh, it's pretty darn close. So let's take it and add another reference to it, or someone of basic skill in the art, and you say it renders obvious. 103 gives me that little bit of play, which will really help me point out to the court when the patent really shouldn't have issued. It was really straightforward as a very basic step, even if no one had written exactly this before, which is going to happen all the time. People don't write down obvious things necessarily, but that doesn't make them any less obvious. So one thing I want to point out to you at 103 is you can put together a couple references and tell the story. These are the references they would have been put together. This is what they would have taught. The other thing I want to point out to you about 103, though, is there's another type of evidence that we're now required to use in court. It's harder to use it at the patent office, but we're required to use it in court. And that is objective evidence from the real world. Here's what I mean by that. Imagine you roll out a new patented product and people start writing reviews saying, oh my God, I can't believe this works. Unbelievable, I'm so excited about this. Well, that is untainted real world evidence that it wasn't obvious. Or imagine you propose something and people in the field tell you that'll never work. I'm not going to invest in that. That's a daydream. That's never going to work. And it does. Well, that's great real-world evidence. You know what? It wasn't obvious. Or you roll out a new patented product and it is a wild success. It satisfies a need that's been out there for years. No one's satisfied. You just did. That's evidence that what you did isn't obvious. And things like this, objective real-world evidence, the court has to consider now. It has to think about that. And that evidence is valued. And the reason it's valued is it's not tainted by the lawyers. The stuff we do in court, I hire my hired gun expert and you hire your hired gun expert, and no surprise, my expert says I'm right and your expert says you're right. And oh, what a mess. The court has to figure out which expert is bending the truth a little bit. That stuff is really hard. We do it, but it's really hard. It's wonderful to have real-world, untainted evidence that helps us say, I don't think that was obvious. Or, oh, wow, that was really obvious. Right? It's really helpful to get this additional information into the flow that the lawyers can't manipulate as easily. It's not that easy to use because you have to link the evidence to the patented invention. So if I roll out a new iPhone, it might sell like hotcakes, and the reviewers might say, amazing, I love the new iPhone. But are they reacting to the new specific patented elements? Or is it just the iPhone overall is really nicely put together and look, Ma, no screws, and whatever it is that gets people excited about iPhones. You've got to be able to tell the story that the skepticism of others, the praise from experts, the awesome sales, the fact that it satisfied a long-felt need, you've got to say whatever it is tightly associated with my patent, the thing I claimed in my patent. But if you can, this is amazing evidence to help us get out of the he said, she said part of litigation. What art counts under 103? Congress didn't bother to write that piece of 103. It spent so many words and the rest of it, they forgot to list what references count. The courts have told us basically anything you can get in under 102A, before the invention date, or anything you get under 102B 1 year before filing. If you can get it into any of the buckets from A or B, you can put it together and use it under 103. That's the art that counts under the law. As of one date, I hesitated even as I read to you. I cringe as I read it to you, because Congress wrote that the date of invention is the important cutoff for obviousness. And as soon as the court started seeing cases, they said, no way we're going to do that. Because they would see 102B cases about 1 year before filing, where the document, someone said, hey, this anticipates. And the court would say, oh, I'm sorry, it's got 10 of the 11 things. It doesn't anticipate. And then as the law was written, that was it. You couldn't do anything more with 102B. And the court said, no way. Like if it's a 102B case 1 year before filing, and the art doesn't anticipate, but wow, it's close. We want to be able to ask, does it render obvious? And remember, 102B is 1 year before filing. It's a different date. It's not the date of invention. And the courts, in the beginning, they'd write these awful sentences. They'd say, it's not 103 art, it's not 102B art, it's 102B/103. They made up a mismatch and said, yeah, that's what it is. And gradually they stopped. They started calling it 103 art, even though the prior art reference was coming from 1 year before filing. It was 102B. It was the wrong date by some reading of the law. But totally settled law now, 103 applies to any art you can pile up under A or B. If you can do it under 102A or 102B, you can use it for 103, despite what Congress wrote in 103. We've kind of loosened that up. All right, last bit of information for this segment on patent law, the new law. Everything I've said to you is under the old law. Old 102A was, is it new as invention date? Old 102B is 1 year before filing. Old 103 is, let's look at all of that, but new verb. The verb is renders obvious. We moved effective 2013 to a first to file system, and almost everything moved over with us. I'll read it with you in a moment, but the same kinds of references, yeah, we're gonna look at those. The same kind of questions about anticipation and obviousness. Mainly what we changed is the date. Instead of having these two dates, invention and 1 year before filing, the first to file system largely said, let's look at the filing date. As of the filing date, was it known? As of the filing date, had someone else filed, because first to file wins. And so Congress rewrote it. Annoyingly, they used the same number. It's again 102 and 103. They used the same numbering system, but they changed the substance in this one main way. And here's what they wrote. 102A1. A person to be entitled to patent unless the claimed invention was patented, described in a printed publication, or on public use, or on sale, or otherwise available to the public. This time they use a phrase like, here's the intuition, available to the public, before the effective filing date of the claimed invention. And so when you file, we ask, did we already know it? If we did, you're going to have a lot of trouble getting the patent. There are a couple little exceptions, but you have a lot of trouble getting the patent if we already knew it. And not on the screen, there's a 103 that does the same move 103 did last time. It's not just anticipation, it's also obviousness. So move 1 in 102A1 is familiar categories, patented, described in a publication, public use, on sale, plus this bucket, otherwise available. Note there's no language about in this country or other countries, right? By the time we rewrite this, we realize if it happened in France, yeah, it counts. And so familiar buckets, the big change is it's before your filing date. That's when I judge you. It's your filing date. 102A2 then again applies the intuition about competing filings. Person gets a patent unless the claimed invention was described in a patent issued under one section or an application published under a different sections in which the patent or application, as the case may be, names somebody else and was effectively filed before the effective filing date of yours. 102A2 basically says you don't get the patent if someone filed before you for the same thing. A first to file system. Two quick things just to add, just as we think it through. One is there are some exceptions. I'm not going to go too far into them now. There's one that will come up from time to time, which is that your own work doesn't count against you for a year. And so if you cause something to go public, that will count against you ultimately, but we give you a year. And it's kind of a rule in the spirit of old 102B that you get a little bit of time that you could let some stuff leak out to the public, maybe decide if it's worth patenting and so on. Your own stuff doesn't hurt you. There are a couple other exceptions. I always tell clients don't lean on any of the other ones because they're so unusual that they won't protect you in other places. They might protect you in the US, but not abroad. Moreover, they're so poorly defined that you don't want to be the test case to figure it out. And so basically, we're in a first to file system with the only meaningful exception that I think clients will actually kind of use. The only meaningful exception is your own stuff doesn't hurt you so long as you file within a year. Your own stuff hurts anyone else, but not you. But in general, my advice to clients is file, file, file. A first to file system, let's not play with the exceptions and the possibilities. Let's win. Let's be the first to file. So there's a lot of pressure now to file. There always was. In a first to invent system, it's not like it's say to clients, hey, you invented, relax, I'm sure we can prove it. Even back then, we'd say, let's file, let's get on record in a very provable way. But man, a first to file system, that's even more true. The other thing I want to point out to you, in case it's slowing you down as you're reading, Congress wrote about effective filing dates, not filing dates. And you might be wondering, what's that? And what that is when I file a patent application, imagine I filed on a Monday and my patent is moving along. And on Thursday, I think to myself, oh, I wish I had written my claims differently. I had my original set of claims, I wish I'd done them differently. There are various procedures I can use to come back and file a new application. I'm going to say Thursday, it might be 2 years later, but just to have an easy set of a timeline in our head. I did original application on theoretical Monday. On theoretical Thursday, I realized, man, I wish I'd written different claims. I can come back and file again on Thursday and tell the government, I'm not adding any substance. All I'm doing is changing the claims that explain what I think I own. And if that's true, my Thursday filing is treated as if it was filed on Monday. And how we see this play out is I'll file in 1 year, I'll get my first patent to issue, I'll then get pushing and pulling with licensees and competitors. I'll realize, man, I wish I'd said it a little differently. I'll come back maybe 2 years later and I'll do this. I'll say, hey, government, I'm not adding substance. I already taught all the substance back 2 years ago. All I'm doing is changing some of the legal window dressing. I'd like you to pretend like I filed this back then. I didn't. But I'd like to pretend like I did because all I'm doing is changing the legal trappings. And the effective filing date of a patent in my examples is if you filed on Monday and show back up on Thursday, the Thursday application is deemed to have been filed on Monday. Or if I file in year 1, come back in year 2 or year 3, the later application is deemed to have been filed when you gave the substance. When you gave the drawings and the prose and all the descriptions, the thing you're changing is claim language, and we allow you to do that later and kind of backdate it to the original filing. As you can imagine, this makes the patent system messy sometimes. As your competitor, I look at your patent and I have to think, well, are they going to go back to the patent office and make some changes? It adds some confusion, some risk, some uncertainty to the system. But that's what Congress was thinking about when they wrote effective filing dates. You're judged as of the date we deem it to have been filed. This also comes up internationally. If I file in Europe and later come to the US, I can get credit for my European filing date, assuming I followed some procedure. And so effective filing date is just a nod to all of that complexity. All right, that's all I wanted to cover on prior art. We learned about references. We learned about anticipation, inherent anticipation, obviousness, and we did it under 2 versions of the law. The first to invent system about novelty and the 1 year before filing, statutory bar, and then the section 103 on obviousness, and then the more recent law, which moves us to first to file as our main theoretical framework, with then a couple little exceptions here and there.